In terms of the English fluency issues, English only workforces, this requirement to be fluent in English is legal if fluency is required to perform the work effectively. So if it is essential to have a very clear command of English, essential to the job for whatever reason, then you can require fluency. But otherwise, accents, are issues that usually do not interfere with someone's ability to communicate. And limited English, we can still get the basics across to be able to communicate. English only policies are becoming more relevant, but really the Supreme Court hasn't weighed in on English only policies. It doesn't really make any sense in my mind, but lower courts really vary in the way that they think about this idea of having, English only workplaces. Obviously, for safety reasons, people need to be able to communicate to each other. So we need to have a common language around that. But some of the challenges are, do people get to speak their native language when they're on a break? Is that okay? I mean, if they're not getting paid when they're on the break, or maybe they are getting paid, does it matter if they're speaking in their native tongue to somebody else who can communicate with them? Is that all right? And it should be all right. Blanket fluency requirements are really disfavored by the courts. You can't assume that every job has to have English as an essential language. And there's no reasons why people can't speak some basic English, but also communicate to friends and colleagues and similar people, speaking with the language that they're most comfortable with. I mean, and that should be all right. But as I said, the Supreme Court really hasn't weighed in on it, and really the only way that we can require it um, um, is if it is to absolutely perform the job effectively. Even the EEOC argues that excuse me, blanket fluency requirements um, just vary from job to job. I mean, fluency needs vary from job to job, so you can't have a blanket requirement even in a particular company. So it is important that we address fluency on a job by job basis and not a blanket policy that everybody has to follow it for just reasons of control and things like that. The courts have allowed some restrictions that were based on very good business interests, business practices, as I said, workplace safety, supervisory control and efficiency, customers and coworker relationships. Um, if your best bet is to stay within a business justification to determine what is the breadth and scope of having an English fluency requirement in your organization. There is some recent state legislation in California said that English only if if it's business necessity, if it's narrowly tailored and it's limited to on-duty times. So that means off-duty or during breaks or during lunchtime, people can speak whatever language they want. So it has to be very precise with very clear boundary conditions and very narrowly applied. Right? When we're thinking about the term adverse employment action, largely what we're talking about is taking away somebody's benefits, taking away somebody's opportunities, taking away their privilege of employment through demotion, meaning they go from a higher level position to a lower level position, termination, where they're let go entirely, and a removal of privileges afforded to other employees. So, you get to take a lunch break, but you don't. You have to sit at your desk. So that's considered an adverse employment action. A good example is in the Vega versus Homestead Union School District case. With respect to harassment based on national origin, we have seen claims have really increased since the late 1990s. Um, Familiar prima facie case elements, again, it has to be unwelcome. It's based on national origin. It's so severe to change the terms of my employment or toleration. The company, how involved the company was, is usually based on the standard of knows or should have known. And obviously, if jokes are going on the shop floor, if they're going on in the lunchroom, if they're going around in more public arenas, the company knows, and no one's doing anything about it. And that's where the challenge comes into play for the organization. They have to address that issue. Common incidents include things like ethnic slurs, calling people lazy Mexicans or, um, you know, um, you know, towel heads or, other things based on ethnic associations for people. Any kind of workplace graffiti where we're denigrating another culture, jokes about other cultures, all those sorts of things. Anything that is presumed to be focusing on an employee's traits because of their ethnicity. Um, the standard that we are held to is whether or not a reasonable person would find that conduct offensive and or hostile. And of course, what that's a hard standard because what is the reasonable person, um, and we'll talk a little bit about reasonable person versus the reasonable woman standard when we get to the section on sex discrimination. But it is interesting that the standard that we hold is the reasonable person. Would the average person, would the reasonable person say a joke about someone's ethnic group? Would that be considered offensive? And the reasonable person would argue probably yes. There is an overlap between religion and national origin, and as we talked about, certainly people who are Greek tend to be Greek Orthodox. If you're from the Middle East, tend to be Arabic, um, and Islam Muslims. South America, largely Catholic. So there's a wide variety of overlap between ethnic groups and religious groups. And federal agencies or contractors have an affirmative duty to prevent discrimination based on religion or national origin. Um, and that's, something that we have to be largely aware of. So some of the guidelines on national origin deal with groups that are not covered under national origin or religion. And that includes blacks, Spanish surnamed Americans, Asians, and Native Americans. And these are all covered under race. They're not covered under national origin or religion for that matter. So be careful about some of the nuanced ways of differentiating who's covered under what areas. Blacks, Spanish surnamed Americans, Asians, Native Americans are all part of race, and other groups would be, when we talk about the country of origin, specifically, we can say, being anti-Chinese or anti-Indian or, anti-Russian or what have you. That's about national origin. There's a huge rise in Middle Eastern discrimination after 9/11 because it was people from Saudi Arabia who were flying the planes into the World Trade Center towers, into the field in Pennsylvania, and into the Pentagon. Um, and so there is then that overlap between someone who's from the Middle East and assuming that they are Muslim, um, when in fact they may not be. So the assumption, the high correlation between someone who's from the Middle East and someone who is a Muslim is fairly high. So there was a code Z that was developed by the EEOC, which is to designate complaints of backlash discrimination from individuals who were perceived to be Muslim, Sikh, Arab, Middle Eastern, or South Asian. And again, it's backlash because they were being harassed because they caused, the 9/11 disaster. And recently, right, there's been an anti-Asian backlash because of the COVID virus coming from China. So again, the anti-Asian mentality is coming from the fact that we assume all Asians, or these people are assuming that all Asians are guilty of this simply because they happen to be Asian and the virus came through China. So um, those are part of Code Z or backlash discrimination issues. Um, the key discrimination issues for whether or not it's national origin versus religion has to do with if it's different treatment because of religious attire, then that is more of a religious issue. Ethnic harassment oftentimes happens because it's related to safety concerns, like we need to be safe, we need to keep our country safe from terrorists. So we make the assumption, unfairly, that every person who looks like they're from the Middle East must clearly be a threat to the United States. So they're subject to more stringent security checks, more pre-employment requirements, a lot more background checks involved. And so it's, the Patriot Act, I don't think did us any services. And we'll talk a little bit about the Patriot Act later on in the chapters towards the end of the book. But it's definitely this sort of backlash discrimination is not uncommon, and it's continuing now with Asians because of the COVID virus. So I think it's something we should be very aware of. To not necessarily lump all groups of people together, to assume that every person who looks like they're from the Middle East therefore must be a terrorist. It's a ridiculous assumption. The Immigration Reform Control Act was looking to figure out how can we manage and illegal aliens or undocumented workers from being able to work in the United States. And one way that they do this is by having people fill out the Immigration Reform Control Act, the I-9 form that illustrates through certain documentation um, that they are eligible to work here in the United States. That was the whole point of the act. It was that it's unlawful to knowingly hire, recruit, or refer aliens not authorized to work in the United States. So we cannot hire someone who is not eligible to work. We can't recruit them. We can't even try to refer them for jobs if we know that they're not going to be eligible to work here. We want to be careful, though. Non-U.S. citizens can be restricted from certain jobs in government and other positions by statute. So it is important that we differentiate between, you know, national origin discrimination and citizenship discrimination. We don't have to hire citizens, but we do have to hire people who are eligible to work here in the United States with a green card or if they have a visa to be able to work. Citizenship should not be a pretext for national origin discrimination. So we have to be really clear and narrowly apply this ruling on whether or not someone absolutely must be a citizen to do the job. That has to be very clearly defined and has to have really clear security reasons for why that might be.